Okay, this is the 10120 class, and we're going to do some drills. These are sentences with the ology and ologist endings. For the record, recycling helps the ecology. Pharmacology is about drugs. A hematologist drew the blood. The CEO had a methodology. This is a terminology test. The dermatologist cured it. She went to cosmetology school. They left on a geology field trip. Sociology is the science of relations. Do you believe in astrology? She wrote an entomology paper. Listen to your psychologist. A pathologist determines the cause. Zeus is a god in Greek mythology. Numerology is the study of numbers. He hates going to a proctologist. A female specialist is a gynecologist. He is a theology student. You need to see a urologist. A cure was found by the histologist. The etymologist studies word origins. You owe me an apology. Policemen study criminology. He studied physical anthropology. Okay, these are drills with the ATOR ending. For the record, the dictator was ousted. Turn on the generator. Take them to the duplicator. He's a renovator of old buildings. You need to choose a mediator. Coffee is a known stimulator. The commentator was biased. Use your inhalator. They brought in the simulator. Initiators get things started. He was a paid agitator. The actuator turned on the sprinklers. We hired a negotiator. Network cables require terminators. Ask the navigator for directions. Quick, call the fumigator. Close the refrigerator. The applicator is dirty. He's a great educator. Take the elevator to the top. Press down on the accelerator. The regulator is clogged. Take him off the respirator. Install the new alternator. You have a faulty modulator. Alligator shoes are illegal. She's the document's originator. Tractors are good cultivators. The car's radiator is shot. Check the indicator. These are some city, state, and zip code drills. For the record, Montgomery, Alabama, 36134. Juneau, Alaska, 99801. Denver, Colorado, 80213. Washington, D.C., 20001. Honolulu, Hawaii, 96811. Indianapolis, Indiana, 46249. Frankfort, Kentucky, 40601. Boston, Massachusetts, 02154. Jackson, Mississippi, 39223. Lincoln, Nebraska, 68502. Concord, New Hampshire, 03301. Raleigh, North Carolina, 37633. Oklahoma City, Oklahoma, 73141. Providence, Rhode Island, 02903. Austin, Texas, 78722. Olympia, Washington, 98501. Victoria, British Columbia. Winnipeg, Manitoba, R3M 2Y6. Cheyenne, Wyoming, 82001. Phoenix, Arizona, 85018. Hartford, Connecticut, 06132. Tallahassee, Florida, 32301. Boise, Idaho, 83762. Des Moines, Iowa, 50336. Baton Rouge, Louisiana, 70858. Lansing, Michigan, 48931. Jefferson City, Missouri, 65101. Okay, this is some literary material at 100 words per minute. For the record, before we begin, I am going to take a minute of your time to briefly explain the different phases of a trial so that you will have some idea of what is to come. The first step will be opening statements. Either attorney may make opening statements, although the defense attorney may wish to reserve making his opening statement until after the plaintiff has completed his evidence. Opening statements are not evidence, neither are they arguments. They are intended only to help you understand what the attorneys believe the evidence will show. The plaintiff will then offer evidence first because he has the burden of proof. Evidence consists of the testimony of witnesses exhibits admitted into evidence, and stipulated facts. The defendant will then present evidence in his own behalf. The plaintiff may then offer what we call rebuttal evidence offered to refute or rebut the evidence offered by the defendant. If so, then we go back to the defendant to see whether or not he has any surrebuttal evidence to present. At the conclusion of all of the evidence, you will be excused for a period of time, and I will go back into chambers with the attorneys and their clients if they wish to be present as well, and we will discuss the instructions or the substantive law that will govern you in this case. This may take 1 hour, or in lengthier and more complex cases, it has been known to take up to 2 or 3 days. After decisions have been made as to which instructions are to be used, you will be called into the courtroom, and I will read the instructions to you, which you will use in arriving at your verdicts. At that time, you will have all of the evidence and all of the law. The attorneys will then make their closing arguments to you. Like opening statements, closing arguments are not evidence. They are made for the purpose of convincing or persuading you, which is a legitimate function of closing arguments. At that point, you will take the instructions and any exhibits admitted into evidence into the jury room to begin your deliberations. During the trial, the attorneys will make objections. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered. Do not draw any conclusions from the objections or from my rulings on the objections. If I sustain an objection to a question, that means the witness may not answer the question, or if the witness has already answered the question, I may instruct you to disregard the answer. If I do, such evidence is to be treated as if you never heard it. It is very important that you pay attention at all times during the trial. Fight the temptation to nod off. You have to hear everything because we are not able to provide you with a transcript of any of the testimony. Legal arguments are occasionally required to be discussed outside the presence of the jury. This may cause some delays, but please be assured that we will do our best to keep this to a minimum. Sometimes you hear of cases where the jurors are locked up, so to speak, during the trial. The reason for doing this is to prevent jurors from being exposed to outside sources of information about the case, which could influence their decision, including information from friends, family, casual acquaintances, fellow employees, and the media. We will not have to do that, but I am going to give you certain admonitions or warnings that will remain with you throughout the course of the trial, regardless of whether you are in or out of the courthouse. The first one is that you are not allowed to discuss this case with anyone until the trial is over and you begin your deliberations. Until that time, you cannot even talk with your fellow jurors about the case. Don't share your impressions or make any comments or characterizations about the case until you begin your deliberations. You can tell your family, for example, that you are hearing a civil case, but please no more. If you think about it, the reasons for this are obvious. If you talk with anyone about the case, they may want to impart to you their worst case scenario, their bias, and their prejudice. It is difficult enough to deal with your own biases and prejudices. It is absolutely essential that you not be influenced in any way by outside sources. Secondly, you might commit yourself one way or another before you have heard all the evidence, considered the instructions, and discussed the matters with other members of the jury. You have to keep an open mind. You don't want to make quick decisions before you have heard all the evidence, the instructions, the closing arguments, and have had an opportunity to deliberate. Neither are you allowed to be an investigator. You can visit the scene, and you can't refer to outside sources of information. A primary and very important example is that you cannot refer to a dictionary for the definition or meaning of words. The instructions will have definitions of all the words or phrases you need to be concerned about. It is also possible, however remote, that there could be a story about this case in the newspaper or on television or radio. We don't need a reporter's interpretation about what happened in the courtroom. Also, there could be something reported that occurred outside of the courtroom, and you know you can't consider anything that took place outside of the courtroom. Therefore, you must scrupulously avoid reading about or listening to any accounts of this case in the media. As for people connected with this case is concerned, it is best not to talk with them at all, not even to say hello or ask them for the time of day. You will find that the attorneys, at least, will generally avoid talking with you, and not out of any unfriendliness, but to avoid any problems. Okay, this is some congressional practice. This will be at 120 and probably a little at 130 words per minute. For the record, Mr. Gable, ladies and gentlemen in this chamber, and Mr. President, I want to thank the senator from Iowa for his insightful comments. I agree 100% with his point of view. We are facing many problems in this country, and this issue is one that should be addressed immediately. It is timely and on the conscience of many Americans. One of the greatest losses to our economy and to the nation as a whole is that women have not been able to take a more active role in the daily affairs of the business of America. Their input would be an invaluable asset to the corporations and businesses of America. Their expertise and experience needs to be tapped. In my research over the last few months, I have found that many of our nation's most respected periodicals have been conducting in-depth studies and surveys to determine the number of women who are involved in the day-to-day management of corporate America. How many women are involved on a daily basis in business affairs that affect the economy? Business Week magazine recently conducted a survey of over 10,000 women who are currently involved in management in corporate America. There were approximately 5,000 responses to the questionnaire from women across the country. From the responses received from the survey, out of a total of 5,000 top paid higher echelon executives involved in corporations and businesses in the United States, 22 of those positions were held by women. Of those 22 women, 15 were in positions of responsibility because of family circumstances. 8 of the women were married or had been married to the chairman of the board or the main stockholder of a major corporation. 7 of the women had inherited the position from another family member who was deceased. Another 7 of this total had actually worked their way up through the ranks of the corporation to an executive position or a position on the board of directors of a major corporation through diligence and dedication. From these statistics, we realize that female representation in corporate America is sadly remiss. What we need to ask ourselves is how this situation came to exist. We need to ask many questions. Is this a gender issue? Is this a man-made issue? Is this the natural order of things? How did this situation come to pass? Have women been given an equal chance to succeed in corporate America? Do they want to succeed in corporate America? Is the male-dominated scene in today's business world a situation that exists because women are just not interested in becoming leaders in big business? Have women ever been given the chance to succeed in corporate America? Until radical changes in the last 20 years, some of the better colleges and schools in the United States of America were classified as men-only institutions. This belief is nothing short of ridiculous. It fosters the old school of thought that women belong at home behind the stove, cooking, cleaning, and caring for the family. Women excel in areas where men fall short. It has been proven that women are as intelligent as their male counterparts. They should be given a chance to climb the corporate ladder. They should be given an equal chance to compete in today's world of business. We should not only encourage women to seek an equal chance, we should enable them to get that chance. As the representatives of the people, it is our duty to ensure that women receive the same opportunities as men. We must afford women the same career paths that are available to their male counterparts. Women are beginning to get into the top law and medical schools. In some regions of the country, women students make up over 50% of the student population. The doors are opening for women, but it is a slow process. We, as members of Congress, should do our utmost to encourage student loans and grants for women. We should discourage any legislation that does not promote gender equity. As members of the House, we should work towards social and economic equality for the sexes. The problem this chamber is faced with is quite a perplexing one.